Hello and a warm welcome to Well This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notification for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court upheld the Tamil Nadu government's law allowing the bull taming sport of Jallikattu in the state. The five-judge Constitution bench headed by Justice K.M. Joseph stated that when the legislature had declared Jallikattu to be part of the cultural heritage of Tamil Nadu, then the judiciary cannot take a different view. The Supreme Court stated that the Prevention of Cruelty to Animals Tamil Nadu Amendment Act 2017 substantially minimizes cruelty to animals in the sport. The Act includes a number of measures to ensure welfare of bulls, such as requiring them to be properly fed and watered and prohibiting the use of any sharp objects or chemicals on them. While Tamil Nadu Law Minister S. Raghupati termed the verdict as historic, the animals' right organization PETA termed it as anti-Tamilian and anti-Indian. Traditionally played during the Pongal harvest festival in the Tamil Nadu, Jallikattu is a bull taming sport that is also known by many other names. The sport involves a young man attempting to tame a bull by hanging on to it for as long as possible. Although it holds great cultural significance to Tamil Nadu, animals' rights groups, including People for the Ethical Treatment of Animals, PETA, had challenged the Tamil Nadu government's law that allows the sport in the state. They argue that the Jallikattu is cruel to animals and that it should be banned. The Supreme Court has held that the powers under Articles 226 and 227 of the Constitution are meant for taking care of situations where the High Court feel that directions and orders are required in the interest of justice. The division bench of Justice Krishna Murari and Justice Ehsanuddin Enamullah observed the High Court is a constitutional court with a broad range of powers, and in accordance with Article 226 and 227, it possesses original, appellate and suo motu jurisdiction. When the High Court determines that the direction or order is necessary in the interest of justice, it may use the authority granted to handle the matter. It was furthermore observed that the High Court's proper course of action should have been to limit itself to accepting or rejecting the accused's request for under Section 439 of the Code. The High Court, however, is not allowed to close its eyes after concluding that there had been serious errors made by the investigating and police machinery that could have had fatal effects on the delivery of justice. It was thus noted that the single-judge bench, after establishing reasons and grounds for the consideration, ought have ordered the intimation of the separate proceedings by using Article 226 of the Constitution. Following that, the issue should have been sent to the learned Chief Justice of High Court for placement before a proper bench, which would have proceeded in line with the laws of the course after providing the person of people being prosecuted and a fair opportunity to respond, the court opined. The Supreme Court has underlined that its shoulders are broad enough to deal with inappropriate statements made by any authority as it declined to entertain a petition demanding action against Vice President Jagdeep Dhankad and ex-Union Law Minister Kiren Rijiju for their contentious remark on the judiciary and the collegium system of appointing judges. A division bench of Justice Sanjay Kishan Kaul and Justice Ehsanuddin Enamullah affirmed the Bombay High Court's position which had emphasis that the credibility of the Supreme Court of India is sky high and that it cannot be eroded or impugned by the statement of individuals. The apex court was hearing an appeal filed by the Bombay Lawyers Association against the Bombay High Court order. In its appeal before the High Court, the lawyers' body alleged that Rijiju and Dhankad disqualified themselves to hold the constitutional post by showing a lack of faith in the Constitution through their conduct and utterances made in public against the Supreme Court and the collegium. The association referred to a raft of the statements made by Rijiju and Dhankad over the last years, marking an ongoing confrontation between the executive and the judiciary over the judges' selection mechanism and the division of power between the two. The row witnessed Dhankad and Rijiju questioning the collegium system of appointing judges. The top court responded with stern reminders to the government that the collegium system is the law of land and that must be followed by the government. The Supreme Court has questioned about the source of power of Delhi's Lieutenant Governor under the Constitution and the law to nominate 10 aldermen to the Municipal Corporation of Delhi MCD without the aid and advice of the elected government. A bench headed by Chief Justice D.Y. Chandrachud, hearing a petition filed by AAP government challenging the nomination by the Lieutenant Governor to the MCD, asked Additional Solicitor General Sanjay Jain, appearing for the office of the Lieutenant Governor, about the source of power with regard to the nominations. The law officer referred to the reply filed by the Office of the Lieutenant Governor, and the constitutional scheme said that the concept aid and advice in the context of the administrator's power to nominate members in the MCD is different from the one which has been portrayed by the Delhi government. On the other hand, senior advocate Abhishek Manu Singhvi, appearing for the Delhi government, referred to the 2018 and the recent Supreme Court Constitution Bench judgments on control over the services and said that the Lieutenant Governor has to act as per the aid and advice of the government, and he should have been taken back the nomination by now. Next we have Delhi High Court. The Delhi High Court has held that a compassionate appointment in an exception to the rule, and appointment should be made only based on the merit. Asserting that the candidates should only be hired based on their merit, a division bench of Justice Manmohan Singh and Justice Saurabh Banerjee observed that the goal of a compassionate appointment is to assist a deceased person's family in overcoming their financial hardships and getting through an emergency. The court cited Umesh Nagpal versus State of Haryana and others, among other cases, to note that it is well established that legal precedent that appointment made on compassionate grounds are an exception to the general rule, and the recruitment to public services must be done in a transparent and accountable manner by giving all eligible persons the opportunity to compete and participate in the selection process. The Delhi High Court, in the lawsuit filed by Microsoft against the Assistant Controller of Patents and Design, has held that just because an invention involves computer programs and algorithms, it shouldn't automatically be considered as a computer program, and instead it should be evaluated based on its technical advancements and practical usefulness in solving real-world problems. The court, in the appeal which was focused on the controversy surrounding the interpretation of the phrase computing program per se in the exclusionary section 3K of the Patents Act 1970, set aside the previous order on section 3K of the Act and found that the subject patent passes the first step. However, since there was no discussion on other requirements and the order was passed solely based on non-patentability under section 3K, the matter was remanded back to the controller for further action. The court also opined that the Indian Patent Office need to change the way it evaluates computer-related inventions by considering their technological advancements and practical applications instead of just focusing on the use of algorithms and computer executable instructions. An invention should not be labeled as a computer program simply because it uses these elements, but should instead be evaluated based on its ability to solve real-world problems. A more thorough process is necessary to ensure that the worthy inventions receive appropriate patent protection. Now let's have an overview of other high courts. Observing that issuance of a few rent receipts by the owner of the occupant in case of requisite premises doesn't amount to admission of a landlord-tenant relationship, the Bombay High Court ordered the Maharashtra government to return 2 flats located in the South Mumbai to their owner, a 90-year-old woman, after more than 80 years after they were taken over in 1942. The court's decision was based on a writ petition filed by Alice D'Souza, the owner of the flats, and was partially granted by a division bench of Justice R.D. Dhanua and M.M. Sathya, who directed the state government to return the flats to her. The court observed that the state government has wide-ranging powers and under Bombay Land Requisition Act, which are not limited by the Continuance of Powers Act. Therefore, the notices and orders passed under the BLR Act for requisition premises are within the jurisdiction of the government. The court also upheld that the subject premises have continued to be under requisition and no landlord-tenant relationship was created by the operation of law. The court rejected the argument that the legal heirs of the original allottee were tenants and could only be sued by the owner as they did not continue to serve the government for which the requisition was made. Reliance was placed on the judgment of the Apex Court in the matter of H.D. Vora versus State of Maharashtra and Roy Estate versus State of Jharkhand, and it was held that the issuance of a few rent receipts by the owner to the occupant in case of requisition premises does not amount to a change of the legal relationship between them or any admission of the landlord-tenant relationship, especially when non-handling over the possession of to owner has resulted in the said premises remaining under requisition. The Allahabad High Court has observed that a magistrate who has received a police report under section 191B Criminal Procedure Code can issue a summon to someone even if they have not been named as an accused in the police report of FIR. based on their statements under section 164 of the Criminal Procedure Code. The single judge bench of Justice Manju Rani Chauhan clarified that before issuing a summons, the magistrate must examine the available material to establish a prima facie case and that people other than those mentioned by the police were involved in the offence. The court clarified that the magistrate is entitled to take cognizance of an offence under section 191B of Criminal Procedure Code even if the police report is to the effect that no case is made out against the accused, and explained that the High Court can exercise its power under section 482 CRPC to prevent the abuse of power of any law or court or otherwise to secure the ends. The Gujarat High Court has held that the arbitration clause in a partnership deed cannot be used to refer dispute between partners to arbitration once the partnership has been dissolved. The case pertained to an arbitration clause that allowed disputes related to the dealing of firm to be referred to arbitration. The court noted that the term dealing means engaging in business, and as argued by the respondents' counsel, clause 24 operates only when the firm is subsisting, and further refer to the case of Mohanlal Sajandas versus Harshikesh Narandas and others, wherein it was held that once partnership is cancelled, the dispute cannot be referred to arbitration. The Jammu and Kashmir and Ladakh High Court has stated that a banking company has the liberty to develop policies and guidelines to distinguish between borrowers who have a high likelihood of recovery and those who have a low probability of recovery. The mere fact that a banking company has created a scheme that excludes borrowers with high chances of recovery does not necessarily mean that such a scheme or its provisions are discriminatory towards the excluded borrowers, the court held. Further, referring to the case of the Bijnor Urban Cooperative Bank versus Meenal Agarwal and others, the court held that the eligibility criteria listed in the one-time settlement scheme are essential for the grant of benefits under the scheme. Additionally, it should be presumed that the banks exercise prudence when deciding to include or exclude certain classes of borrowers in the OTS scheme, taking into account the public interest involved. Therefore, the court noted that if a borrower wishes to challenge a guideline or convenient of an OTS scheme that excludes them from its scope, they must demonstrate that they had been unjustly discriminated against. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.